Good day, Ms. Fahana. We are from Group 11. First, the issue of notice of writ outside of jurisdiction. The first challenge faced by the court is a high threshold to satisfy the elements inherent in granting a notice of writ outside of jurisdiction. The court must be exceedingly cautious in exercising their discretion, as it is a direct interference with the exclusive jurisdiction of a sovereign state. The court also faced challenges in examining all the relevant and material facts of the case and demand for full disclosure from the parties, as there is no requirement for a full and frank disclosure under Order 11. Besides, the court also must solve in favor of the foreigner or defendant if there is any ambiguities on the construction of the rule. And lastly, the court must consider the appropriate forum for the case. Therefore, it is quite a burden for the courts to exercise their discretion in granting the writ outside of jurisdiction, as the threshold is very high.
Moving on to the issue of stay of action. 3 factors to be considered: forum non-convenience, foreign jurisdiction clause, least alibi pendants. On the issue of forum non-convenience, Malaysia court applied the appropriate forum test set out by Spiliada case. By the test, the court would determine the appropriate forum which the case has its closest and most real connection. However, there are several challenges that faced by the courts in applying the test. This test is said to have confers to Malaysian judges a discretion that is too wide that causes uncertainties. The factors which the court may consider in determining whether another forum is more appropriate are too broad and no guidance was given as to the way of the various factors. This perception of Spiliada doctrine, which affords courts an unduly broad discretion, also played a significant role in Ocean Sunline case for the High Court of Australia to refuse the doctrine. It is submitted that the main source of this problem is under second limb of the Spiliada test. The first challenge is that the second limb of Spiliada test may lead to unpredictable outcomes. This can be seen in the 4 English cases listed below, where even though these cases were with similar issues for consideration, but they have obtained different outcomes in applying the Spiliada test. This has supported Professor Robertson's criticism in his article that, under a doctrine like Spiliada, seemingly indistinguishable cases have far too often yield diametrically opposite results. Secondly, it is resource inefficient, as almost any factors can be taken into consideration in applying second limb of the test. As a result, the court has to go through a sizable volume of evidence, and this evidential burden further complicate and lengthen the hearing on where the dispute should be litigated. The following passage in Ultimo holding cases also criticized that all the work done was wholly disproportionate to the issues of law and fact raised by the parties. Lastly, the second limb of the test may lead to judicial chauvinism, as it may use as a channel for the court to call into question the quality of justice of a foreign legal system, although it requires the parties advance sufficient amounts of evidence to establish that the foreign courts were unable justly to resolve the dispute involved. Nevertheless, the fact that it draws the court into such an inquiry is undesirable in as much as it encourages judicial chauvinism.
The next challenge arises when Malaysian courts use the LIA3012 approach to deal with foreign jurisdiction clauses. There are 3 main challenges faced by Malaysian courts when applying this approach. Firstly, inconsistency due to courts exercising their discretion, and this can be seen in the High Court and Court of Appeal decision of World Triton Corporation, where upon the High Court decision that the respondents had shown a strong case to override the forum selection clause was overruled by the Court of Appeal on the basis of the considerations accepted being insufficient. This proves different views of courts exercising discretion will lead to different results in deciding if the plaintiff's burden had been discharged. Secondly, there is no guideline to decide whether exceptional circumstances amounting to a strong case have been proven. In the World Triton case, the court referred to the various factors in the LIA3012 and held that the respondents would have to show exceptional circumstances to discharge their burden. The court in the Open Country Dairy Limited case also held that they did not find any convincing evidence that will qualify as exceptional circumstances. Evidently, the lack of a standard test to decide what amounts to exceptional circumstances will lead to inconsistencies of judgments and the plaintiff's hardship. Finally, the third challenge is observed in intermaritime management, where it was laid down that when applying the LIA3012 principles, the court must consider all circumstances of the case and will face difficulty in deriving assistance or precedence from other decided cases, as each case is dependent on its own facts. This may be time-consuming and adds burden on the judge in coming to his final decision. To conclude, it is submitted that support of the LIA3012 approach had demonstrated the Malaysian court's willingness to uphold parties' bargain on the pre-agreed exclusive jurisdiction for dispute resolution. However, a standard guideline is still needed to provide further clarity and assist courts in making their final decision.
Lastly, the issue of anti-suit injunction. The first challenge is In order to grant injunction, the other party must be within the Malaysian court's jurisdiction, for otherwise it won't bind him if the party is a foreign resident. This will be a challenge and raise difficulty for courts to determine whether they have the jurisdiction to do so. Next, the Malaysian courts must concern with the ends of justice as held in society case. The account must not only of injustice to the defendant if the plaintiff is allowed to pursue the foreign proceedings, but also of injustice to the plaintiff if he is not allowed to do so. Hence, the court will not grant an injunction if by doing so, it will deprive the plaintiff of advantages in the foreign forum of which it would be unjust to deprive him. Therefore, there is an even higher threshold beyond the Spilata test when granting anti-suit injunction. To conclude, determination of one's jurisdiction is of utmost importance before the initiation of any legal proceedings. Thus, we submit that the Malaysian court must take into consideration all the aforesaid challenges and deal with them accordingly. That's all from us. Thank you.